Oh, we have questions. Right, oh, I'm sorry. Let's ask some questions. I thought we were going to do questions at the tail end, but go ahead, sir.
Thank you. Professor Weinrib mentioned the problem of what you call result-oriented judgments. And I should admit that in comparative jurisprudence, one can find precedents almost for everything. So isn't there a danger that citation from transnational cases and articles would be used mainly for supporting the specific result which the judges think is appropriate from the personal political point of view?
Okay, well, this is the position that is articulated by Justice Scalia and other people who are fans of restricting discretion through the originalist approach. Okay, first of all, I don't see that this is what's happening in the American cases that are precipitating this debate. Okay, this is why I think the debate is a bit overheated. What I see is that there is the identification of a common project. Let me give a personal example. For 15 years, I was a constitutional lawyer in the province of Ontario, and the Constitution did not contain a Bill of Rights at that point. And not only did I not know very much comparative federalism, any comparative federalism that I knew was a detriment because in my when I would argue cases in the Supreme Court of Canada on the litigation side of my work, I didn't even have to refer to a case of another country. If I started to use vocabulary or started to suggest a line of reasoning that the judges thought was not Canadian, they would stop me. Okay, so that's the way. That was the intellectual universe, if I could put it that way, of constitutional law in Canada before the Charter. The minute we come into the Charter, we were comparativists. We had to be because of this methodology, purposive interpretation, freedom of expression. We had no history ourselves. We had the unwritten British Constitution. We had judges who had mentioned freedom of expression in the context of doing other categories of legal analysis, but we couldn't have gone forward on that basis. The learning curve was unbelievable. We had to, read theory, we had to read comparative constitutional law, but we had to find the material that was relevant by finding the countries that were thinking in this modern way about rights, and also were giving us something valuable in terms of the methodology, purposive interpretation of rights. And because I was a government lawyer, I was doing the proportionality analysis in the second stage, like strict scrutiny. And so it had to be plugged into something. So, and of course, a lot of the comparative material that's brought forward is rejected. And that allows the courts to delineate the distinctiveness of the Canadian system or whatever system they're working in. So when this is well done, I don't think it's picking your friends in a crowd, as I think your Chief Justice had indicated. Okay, so let me make that as one point. Let me then just say something else. Using the material that way is very different from what the American Supreme Court is doing, because the American Supreme Court was saying that the comparative law didn't help them with the actual analysis. It affirmed a decision they came to on the standard analysis, although their standard analysis is not Justice Scalia's. They're not doing this very strict parsing of words in these and historical understandings in his model, but they are using other methodologies, and they were, I think, quite moved by the fact that all the respectable countries that one would want to recognize as being involved in a common project of rights protection don't execute juveniles, don't execute people who are mentally impaired, don't criminalize adult consensual homosexual acts, one can go on. The countries that do that are not countries, I think, that Scalia is going to quote and cite and emulate the way he threatens to. He gives the example of countries in Africa that have a death penalty for homosexual relations of adults with consent. He's not going to put that forward as a model. So I think that there is something about the comparative engagement when it isn't understood as a common venture of countries that are liberal and democratic and believe in this modern idea of the equal inherent human dignity of every person, and that every member of a society, not just citizens and not just white men who are property owners, but every member of society has to be treated by the government as an end and not a means. And so there's a framework for all of this to be filtered through. So I see your point. Another thing that distorts all of this is that judges are quoting their friends because they have all these colleagues from these conferences, so that's part of the mix. The other thing, and I didn't make the point in my main comments because I ran out of time, a huge amount of the comparativism is not footnoted. So while I really respect the analysis that Daphne made, President Barack has influenced other courts and the Canadian court so much in all sorts of areas where, subject matter areas and methodology, where there are no footnotes. So a lot of this is just under the table. And so if the opposition to transnational law wins, the result will be much less transparency, not necessarily much less transnational influence.
Got another question over here.
I just want to link the two papers together, because this is going to be the first time in the history of law, Western law, where an empirical study confirms a philosophic insight. But I think there's a meaning of these two papers that is very powerful, and I just want to, I'm just throwing it out. Lorraine, you said that the hostility to transnational law was premised upon a program of emptying law of any normativity. I mean, you begin with the program against normativity, making judgments, and if you do that, leads you to be hostile to foreign law. We haven't explained the word why foreign, but that's what this program is all about. Now, Daphne seems to confirm that, because when people are turning to foreign law, it's exactly as I think Daphne said a number of times. It's that judges are looking for moral guidance, which is, and so what they're looking for moral guidance, one of these enemies of foreign law are saying, what moral guidance? There is no moral guidance. As you know, there is no place for it. So what you're both saying seems to fit together, and it's premised on this kind of notion about a methodology that denies any space for normativity in the law. And this is just a detail. Maybe they use the word foreign as kind of exploiting kind of nativist ideas in American culture, but that's basically what it's about.
Yeah.
Well, I agree. I must tell you that it's also the first time in history that I wrote an empirical paper, and the reason for that is that I'm not interested in, personally, I'm not that interested in empirical studies. But for me, it was the point was exactly to think about these issues. So I think that the problems are really the problems really express themselves through these examples. I would say that the study confirms to some extent my assumptions when I started to get into this. And maybe since I was given the floor, so I'll just, give you another example, because I did not give enough examples coming from the US, and I thought afterwards that it was inappropriate. So I'll just say that most of the examples in the US context are about a theory of judicial interpretation. For example, is it legitimate to use legislative history, for example, something that is debated in this country, and we see that the minority tries to support its views, by, I would say, inspiration from Barak's writings. So I agree.
Could I just respond to that? Because and I think that was really very sort of sparkling to find that. But first of all, of course, it's Arendt's work. So, the foreign law does different things.
The whole program is aimed at resisting Aaron Barak's influence.
Well, actually, it's very interesting that he got drawn in to that whole debate, and also with overheated arguments that have nothing to do with his judgments or his judicial philosophy. So it's the idea that so much of this is really out of focus is a very interesting trait. But let me go back. It's more than moral. So many of these cases are about the autonomy of the body and the respect for the body. The death penalty, Roe and Wade, the homosexuality, race, which is sort of considered to be sort of a physical and substantial part of the person that stands for difference or negative difference, that kind of thing. So, what a primitive stage we are at when there's this, I think, tremendous moral contrast as to how we deal with people's autonomy in their bodies and the state's control, the state's power to coerce our bodies. So I think that's very, very interesting. The other thing is that there's much more of this for issues of first impression in particular countries, and for socially novel expansions of autonomy.
One more question here.
Yeah. I think study notations can be very interesting in this interesting project. But I think we also ought to remind ourselves, just as you point out, there's a universe of potential things to be starting with. So who cites what and for what reason? And in my own presentation earlier, I pointed out that John Hill cited Justice Barak's opinion for a very specific purpose, that it pronounced that what Israel did wasn't torture. Now, under his reading of Israeli law and international law, it didn't have to be torture in order to be condemned. But if you're John Yoo writing a memorandum where the distinction between torture and everything else is crucial, then the case turns out to be an incredibly useful citation for a purpose presumably very different from the one for which it was written. Similarly, if one were arguing against what, for lack of a better word, I would call a thoroughgoing Kantian approach, then I would certainly, as I indicated in my remarks, cite Justice Barak's opinion with regard to the role of the necessity defense. As somebody whose most widely cited article is one on the Second Amendment, a lot of those cites begin, as even ACLU liberal law professor Sanford Levinson has written, and then it is cited with regard to the ostensibly pro-gun argument. It's much more useful in certain circumstances like me than it would be to cite Steve Halbrook, who's a well-known conservative devotee of the NRA. It's no surprise that he would think that guns might be protected by the Second Amendment. So I think that it is always unclear what opinions really things stand for. And part of effective tactical lawyering is to play a certain jujitsu game. So I'm sure that Justice Brennan has often been cited by conservatives for those sentences and opinions that aren't the ones we most celebrate as part of Brennan's heritage.
I agree, but this is, as you just pointed, is not unique to the practice of comparative law. This is about clever lawyering. And still, it's interesting who has a reputation. So you have this liberal reputation and they cite you, so it says something about you. And so this was the focus of the paper. And of course, there are other relevant perspectives to study the same issue.